Hello and welcome to this update on AI, tech and data law that I'm presenting today, Friday the 10th of October, live from Digital Law. Here we are. My name is Peter Wright. I'm a solicitor and the managing director at Digital Law, and we spend a lot of our time advising our clients around the world on issues around data, cybersecurity and artificial intelligence. And what I wanted to do today was just spend half an hour to make sure that everyone is aware of a lot of the particularly hot button issues that we need to be mindful of at the moment when it comes to the use of artificial intelligence in particular. So we have a few delegates on the line today. We do have, I believe, a few more may join us. So we'll just wait a minute or two in case any more do join us. But this discussion will also be available on YouTube afterwards as well. There is a chat facility, so people are able to ask questions in that chat. Alternatively, please do feel free to put any questions up either during this discussion or afterwards on the LinkedIn or Facebook pages associated with this event. Thank you all for joining today, and I hope that you find today's discussion is both useful and relevant. What I will now do is start to share the slides, and hopefully everyone will be able to see those in full detail. So let's just see if I can bring these slides up, and then off we go. There we go. So hopefully everyone will be able to see this. So here is our AI tech and data law update. In terms of what we'll be looking at, it's very much issues around use of artificial intelligence and in particular the aspects of data protection with regards to its regulation, but also look at a few things like the EU AI Act and its application, and also just best practice when it comes to compliance. Well, first of all, I just want to make sure that people are thinking of issues with regards to the use of AI more broadly. Very often, I think at the moment, there's a perception that when we talk about AI, we mean large language models, things like ChatGPT, Claude, Grok, all of these very powerful, very easy to use chatbots and platforms. That's what we're hearing a lot about. We're always seeing new systems come along all the time. They're getting more and more powerful in terms of what they can do and the levels of creativity that they can deliver. However, AI has been with us for many, many years now, and I think it's worth bearing in mind that AI is seeping into an awful lot of the different systems we use. It's always quite interesting when I ask the question of a lot of people, do you use AI every day? And very often they'll say, no, they don't, to which I then say, well, do you watch Netflix? To which they'll say, yes, they do. And it's like, well, congratulations, you're using AI. Netflix uses AI to select the videos that it thinks you will want to see. It does that to give you the content. Every single thing that you watch changes the algorithm subtly, so it offers you slightly different content. But this is how all now social media platforms work when they're providing content. So TikTok, for example, has a very powerful algorithm that serves content based on what users like to see and gives them this very powerful, very addictive online experience. But we use similar AI systems every day, very often in delivering services. So Grammarly, for example, or Quillbot are examples of AI that can be used for spelling and grammar and proofreading purposes. Fireflies is a transcription system. This allows, for example, if you're on a video call, you can have Fireflies alongside you on that call, and it will take a transcription of exactly everything that's said and then email a copy of that transcription to all of the people that are on the call. Copilot is now embedded in a lot of Microsoft's products and services. But I think the thing to bear in mind here is, are all of these platforms necessarily secure from a compliance standpoint? And that's the thing that I really want us to stop and ask the question about. So, for example, Fireflies in particular there is an example of a transcriber that is, very flexible. It is from the United States. Its servers are in the United States. Therefore, if you're in, say, a highly regulated sector in the UK, say law, accounting, banking, financial services, medicine, pharmaceuticals, you may find that the professional obligations that you are under include a duty of confidentiality. So if, for example, you are on a video conference call that includes individuals who might be clients, who might be other parties that you're going to discuss confidential client-related information with, you may find that using a transcription system that is not entirely compliant and secure in terms of how it handles content could put you in breach of those professional responsibilities. The point is that a transcriber that is located in the United States, and if it's using systems servers there, would have to then demonstrate that its servers are operating in a way that complies with UK data protection law or EU data protection law if you're located in the EU. And the point is that many of these systems don't have membership of the EU-US privacy framework. That's a system that you can check the register and see which corporations are signed up to the terms on there. Many of the larger ones, Meta, etc., are signed up, but an awful lot of these smaller platforms that provide things like transcribers or some of the law tech systems, they are not signed up to the EU-US privacy framework. And if you are signed up to a contract with them and that contract does not include a data transfer agreement, which has supplemental standard contractual clauses attached, and if the corporation does not have binding corporate rules in place, you may well therefore find that the way that personal data is being transferred to those servers in the United States is not compliant with UK data protection law and therefore puts you in legal and regulatory breach. That would be a breach both with the Information Commissioner's Office and with your potential professional regulator. So these really are things that you need to be mindful of. The other thing with AI is that it is, of course, not entirely accurate. It can hallucinate. It very often is a useful tool. It can generate things for you. It can carry out sifts of large volumes of information. However, it is not entirely reliable when it comes to its day-to-day use. And therefore, it is really important to ensure that if it's being relied on, it probably has been checked once or twice by a human being. This has been a problem certainly for many law firms who've relied on it for the generation and drafting of documents and for undertaking research. And then when that research has not been properly checked, it has then been found that, for example, totally false case citations have been created or other hallucinations may have occurred that may not be quite as fundamental as manufacturing fake cases, but could nonetheless mean that you're relying on what you think is a clear factual analysis, when in fact there could be elements in there that should not be relied on. And therefore, AI is something that can be great for creativity, but you need to embed it into the systems within your organization that will allow for good governance, that will allow for systems for AI-generated content to be checked and verified before it is relied on, potentially to your detriment. One of the issues that can come up around the use of AI is where there are no clear guidelines in place around its use. We work with a lot of our clients on actually implementing AI guidelines. These cover the procurement of a system. So looking back at the example I just gave you about AI transcribers, that would show that you would end up asking certain due diligence questions of each provider that you were looking to use as part of the onboarding process. Therefore, you would find out where data was being stored. You would find out what encryption or security measures might be in place. You will be able to confirm whether a system does indeed comply with the tenets of data protection law or any other legal and regulatory requirements that you may be looking to discharge. AI guidelines would also then cover the use of the system. They would ensure, for example, that there could be a human being involved in checking the use of AI, or it could be a matter of ensuring that AI, while it can be implemented, is not going to be relied on to the point that it could be relied on to a point that would cause detriment for the organization. The other thing to bear in mind is that if there are breaches or cybersecurity breaches that take place, this can lead to over-reliance, where people are relying on the information that and the work that AI is undertaking, and then not realizing that by putting information onto these systems, for example, personal data, it could mean that then you're sharing personal data that shouldn't be shared on those systems. Example of this will be using the freebie version of ChatGPT or Grok and just sharing, say, putting on there a letter saying, please redraft this for me, or please check the research that's in here. By relying on these systems to undertake that work and putting personal data into them, you would be inadvertently committing a data protection breach, as well as then leading to the issues around confidentiality that we have already discussed. The issue here is that very often platforms are designed without the requirements of UK or European data protection at their heart, and therefore they don't demonstrate compliance to the legal and regulatory systems that organisations based in Europe or the UK need to demonstrate with regards to compliance with the ICO and compliance with their professional regulators. A further issue is that over-reliance on these systems can indeed mean that you can very quickly get to a point of laziness where work from these systems are not being checked and can then lead to the detriment that we've talked about already. So another thing to consider, and this actually applies not just to any AI system, but to any tech contract, any tech product that you're looking to use, so apps, platforms, cloud, etc., case management systems, data systems, document management systems, contact management systems. Before embarking on onboarding those sorts of contractors, you need to be asking yourself certain key questions. Some of the things that I've listed here might seem obvious, but given the issues that I very often end up having to help my clients with, it suggests that these are not obvious questions that are being asked. And sometimes I'm helping out law firms, I'm helping out accountants, I'm helping out those in financial services and insurance, where they've committed to contracts, they have committed to deals with different providers, and then they've suddenly found that they are either using a platform that isn't suitable, or that they are then locked into a very long-term or onerous contract. Always ask, are you being locked into a fixed term deal? Is there a minimum term? Is it 1 year, 3 years, 5 years? A good contractor will usually say, look, we are confident that you'll like our product, and therefore it's usually quite flexible in terms of how they will sign you up. And if you want to leave, then you can then go after you've given, for example, 1 month's worth of notice. However, an awful lot of platforms out there do have restrictive minimum terms of 1 year, 3 years, 5 years, etc. How long is that contract? Does the contract have a break clause? Will you have to pay excessive penalty fees if you want to leave before the contract term has expired? Are there mechanisms, force majeure mechanisms, that say if the service I'm getting is poor and not fit for purpose, am I then able to break the contract, or am I still locked in? You'll find that we've come across some contractors who, even though their platforms have been victims of data protection breaches, they've been on the end of cyber attacks, they've lost the data, they've put their data controllers in legal and regulatory breach, they have still not been able to get those contracts broken, and the organizations are still locked into their deals with these platforms, even though those platforms have lost the data that they were entrusted to be using in the first place. Are there break clauses? What's the term of the contract? Where is any personal data on that platform going to be kept, and how long for? So what is the data retention policy? If this platform will be acting as a data processor for you, i.e. you're the data controller, you'll be giving this platform data and it'll be processing it to your order, what happens at the end of the arrangement? Will that data be returned to you, or will it be deleted after a certain minimum period? We end up trying to help a lot of our clients at a point where the relationship with the supplier may have broken down, say with a server for a website, or with a cloud storage system for a ordering or distribution channel, and you find that sometimes you can get real arguments developing with the processor that has all of this data, arguing that they will withhold that data for various reasons, even though that puts the data controller at odds, and indeed puts the processor in legal and regulatory breach with the information commissioner. But very often they will ignore this point, and it can lead to very difficult disputes that we end up working with a lot of our clients to try and resolve. So asking yourself that question, where will personal data be kept? What happens at the end of the relationship? How is that end of relationship process governed? How long will it take for data to be returned? What happens if there is any form of dispute? How will those disputes be settled? Is there a resolution process in place that both parties agree to? Do you, for example, commit yourself to arbitration or some form of mediation at the end of a contract, rather than leaving resolution available in the courts of a certain jurisdiction, usually England and Wales, with regards to the end of that contract. But you might find that by not looking at these deals in detail, you might find yourself unwittingly signing away fundamental rights that you might otherwise have wanted to rely on. Most crucially, does a contract that you have with your provider comply with your legal and regulatory obligations around data protection? You may see yourself as a data controller, but does this supplier say, well, we're a data controller and actually we'll end up being joint controllers under this arrangement? Or do they see themselves as a data processor? How do they ensure that you will be able to comply with your legal and regulatory obligations? Or is this a platform that's based in another country that simply isn't bothered about your legal and regulatory obligations and won't support you, for example, if the data ends up being lost in a data protection breach? Again, we've ended up helping our clients very often where platforms are on the end of data protection breaches and they don't end up helping the data controllers. They don't help the data controller to then be able to report that to the breach to their regulators within 72 hours as you have to, and then they aren't providing information so that those reports can be done in detail so that the risk of legal and regulatory enforcement is reduced. Finally, it's also worth asking, are you complying with the appropriate EU regulation? If a platform is storing the personal data of European Union citizens, EU data subjects, a platform should therefore comply with the EU AI Act. If we're looking at a platform that is storing the data of UK data subjects, it should therefore be complying with the UK's requirements around data protection regulation. There isn't an AI Act in the UK, but any artificial intelligence system is required to comply, for example, with the UK Data Protection Act 2018 and the UK's Data Use and Access Act. Bear in mind that UK data protection regulation is now starting to diverge in quite a big way from EU data protection through things like the UK Data Use and Access Act and through the guidance and the enforcement being issued by the UK Information Commissioner. As a result, the way that data protection law is being regulated and enforced in the UK is now becoming quite different from how it is done in the European Union. Therefore, it's always important to look at what the UK data protection regulator is saying with regards to what is expected of systems that are processing, storing, retaining, transmitting the personal data of UK data subjects. Also be mindful of any regulatory requirements issued by professional regulators. So for solicitors, that would be the SRA, or it could be the Financial Reporting Council, Financial Conduct Authority. What are those regulators saying with regards to what they expect their regulated institutions to be doing with regards to artificial intelligence? While there won't be a UK AI Act, it is being made quite clear by the government that they expect different sectors to be making it clear what they expect to be done with regards to regulation of AI, as well as ensuring that any platform complies with the requirements around data protection. And, for example, that a platform might have to comply with the requirements of the UK's Online Safety Act. We are increasingly helping platforms with regards to ensuring that they are complying with the requirements of the Online Safety Act. We're helping game developers. We're helping developers who are developing different systems that might have profiles that could be shadow social media systems, and they are keen to ensure that they comply with the requirements of the UK's Online Safety Act because of the large-scale enforcement that Ofcom can now apply to any organisation that does not comply with the Online Safety Act. So there is a growing hinterland of regulation around the use of digital technology in the UK that organisations do have to bear in mind when they are operating systems storing the personal data of UK data subjects. With regards to the EU AI Act, it is the first comprehensive regulation on artificial intelligence and is gradually being implemented by different regulators across the European Union. It introduces a risk clarification, which includes everything from unacceptable risk to minimal risk, and then attaches requirements in relation to compliance on there as a result. The EU has developed tools like an AI Act compliance checker that can be used if you are wanting to find out what is required to ensure that a system does comply with the EU AI Act. Ideally, the Act aims to foster innovation while ensuring safety and some of the fundamental rights that those in the European Union are used to seeing with regards to those fundamental rights that are in place across the European single market. Compliance obligations can be imposed on providers, developers, and also with regards to general purpose AI, where technical documentation may need to be provided in order to comply with copyright laws. So it is certainly, even though organisations based in the UK, if you are operating in the European single market, you do need to think about EU AI Act implementation as a result. We are working with a lot of our clients across the European Union and the UK with regards to their AI guidelines. These guidelines look at how and when to procure AI and tech platforms. They look at demonstrating compliance in the ways that we've talked about. They talk about authorized and non-authorized AI use, and they also talk about how an employee can use AI and how they should avoid using AI. The point here is that so many of our mobile devices and the apps that we use on a day-to-day basis now use artificial intelligence, that therefore the use of those systems for work-related activities can create problems. An example of this would be the Android Auto or Apple CarPlay systems. Many of these systems now are using AI to mean that if, for example, you ask the system to play a text message that you've just received so that you can hear that message and then dictate a response, that means it is actually feeding that information, which could include personal data and could use client confidential, privileged or commercially sensitive information. That information is then being passed through Google or Apple's AI system. In particular, you should be able to disable the use of AI, and an option is usually given to you by the system to allow you to do that. But this is not necessarily the case on all systems and all versions of Android and Apple's system. So therefore, it is important to check the privacy systems that are in place on your mobile devices so that you can see whether any use that you might be having there of text messages, for example, from WhatsApp or Signal, funneling through those other systems could be potentially putting you in legal and regulatory breach. Other examples would be where systems are being used for dictation, where they're being used, where you might be using a mobile device in order to access systems, to access content, to undertake your work-related activities, and you may inadvertently find that AI is being used by the operating system or in other interactions in terms of how you are interacting with the system overall, and that can be potentially putting you in breach with regards to the use of personal data. There is very often a reason why businesses are trying to provide secure systems to their employees, giving them work-related laptops, work mobile devices, because very often they will have sufficient levels of security in place to mean that they are demonstrating compliance. But if individuals are using their own personal devices, those will not be locked down with regards to the use of AI and other potential privacy risking tools, and that can therefore create a problem. However, some employers aren't making sure that their employees know what the risks are. And an employee who thinks that barriers are being put in their way may inadvertently be putting themselves and the organization at risk if they are dead set on using their personal laptop, their personal desktop, personal tablet, or personal mobile phone for business-related activities, and may unwittingly be therefore responsible for a data protection breach as a result. Therefore, ensuring that employees are trained on how AI is being used in modern technology, are being trained on the reasons why certain working practices are being required by an employer rather than just told what they should or shouldn't be doing, should get greater buy-in then from employees so they don't inadvertently mean that a data protection breach is being perpetrated. By ensuring that you've got good training in place, hopefully it will mean that staff and all employees and all third-party contractors that might be working on your systems are brought into understanding what the risks are and minimizing those risks accordingly. AI is being used in so many different ways now, from creative tasks, generating text, generating charts, videos, pictures, presentations even. And it is great in terms of being a creative tool like that, but having guidelines in place so that personal data, for example, isn't shared on those platforms is an absolute must. Very often research is being undertaken, and of course it's then important to check the outcomes of that research, to check that the content that you're getting is indeed clear and accurate. Very often, AI is being used now to screen CVs, particularly in a world where we're getting hundreds or thousands of applications for individual job vacancies. Pre-screening of CVs to end up whittling down hundreds of CVs down to a manageable number of CVs for human review is now commonly undertaken. Previously, this was very often undertaken with regards to being just done on an automated basis anyway, so it's not a great leap to therefore use AI. However, please be mindful of the requirements in place with regards to data protection and with regards to automated decision making that may be in place to make sure it is clear to individuals who are using different online application systems that automated decision making may be taking place, and make sure that any privacy policies or governance documents that you have in place with regards to those systems are open for inspection, both by the data subjects using those systems and potentially by any of the regulators as well. AI can be great as a productivity tool to help with spelling, punctuation, and grammar checking. However, again, please be mindful of the data protection standards that those platforms may have. It might be fine just to share a couple of paragraphs or to use them for generic document drafting, but be mindful that if you're getting them to draft emails to clients or letters that might contain legally privileged, confidential, or commercially sensitive information, that may again put you at risk of legal or regulatory breach. So moving on from there, I just wanted to talk briefly about some of the support that we provide to a lot of our clients. We act as an outsourced data protection officer to a number of our clients. We have different tiers of support that are available, and we are indeed offering a discount to anyone who is listening to this session today. So we would be happy to apply a discount to those fees. We do different levels of support because, of course, some smaller organizations would only require a smaller level of support compared to some organizations that would require a far greater level of support. So we provide this service for anything from solo, small and startup organizations through to multinational organizations in highly regulated sectors like banking, insurance, finance, etc. And indeed to organizations based in multiple different jurisdictions. So we have clients in the Far East, in the Middle East and across the European Union that we are also acting as an outsourced data protection officer for in this scenario. So therefore you can see there the models that we have in terms of how that outsourced data protection officer service works. We work closely with our clients and their compliance teams. In many instances, we're actually supplementing an existing compliance individual or indeed a data protection officer, but providing them with plenty of support to help them discharge their responsibilities. So it's an outsourced DPO or it's a DPO support package. Very much. But for many of our clients where we are the outsourced DPO, it is therefore our name that is registered with the appropriate data protection regulator to show that we are discharging that role for the client. And you'll see in many instances there that the amounts quoted actually equate to less than the amount that would be paid for one individual in terms of 1 year's salary to carry out a DPO role. So rather than paying that and having one individual in your organization, you can have a whole team of specialists available supporting you with regards to your data protection requirements, which includes everything we've just been talking about in terms of the use of AI, in terms of due diligence when it comes to third-party contractors, producing AI guidelines, delivering training, all of those sorts of things. That's how we like to help our clients, and by doing it on a subscription basis, they can budget accordingly and have the peace of mind that all of these somewhat complex compliance requirements are all being taken care of for them. For any lawyers that are on the line, yes, we also provide this as a white labeling service. So if you would like your law firm to be able to get into providing your help and support for your clients with regards to these sorts of services, we could discuss that with you and do that on a white label service. So the service that your client then receives, as far as they're concerned, they'd be getting that from you. Think of it like a tin of soup. We provide you with the soup, you put your own label on it. Very much is how we see that operating. I hope you found this quick update today helpful. We only have half an hour. If you're interested in this sort of content, we do a podcast. So we produce a free podcast. And indeed, we're going to be recording a session later today all about ID cards in different countries. following up on the issues we discussed on our last episode of the podcast, which was also all about ID cards. So you can see the QR code there, so you can use that to access our Digital Law podcast, and you can then follow that on YouTube. It's also available on Spotify or on Apple. Just search for Digital Law on your podcast app of choice. We also have a Substack in place. Currently, it covers issues around cybersecurity and legal and regulatory coverage with regards to that. But if you subscribe and follow the Substack channel there, we are also developing a Substack channel that will be operating with regards to data protection. And also there'll be one in due course looking at issues around AI as well. So lots of content there on our AI Substack. I hope you found this session helpful. We also produce a lot of very specialist content through MBL professional training services, so you can get hold of some more of our content there. However, if you're also interested in having specialist content produced, please do get in touch with us and we'll be happy to look at delivering an in-house webinar or in-person seminar for you. That could include something to all staff to make sure they're up to speed on legal and regulatory requirements on technology, or we also deliver masterclass workshops to boards and senior management in organizations which are more interactive but allow for boards and senior management to get good, strong understanding with regards to the legal and regulatory frameworks in place and what their legal and regulatory requirements are with regards to the use of technology. Thank you very much indeed for listening. I hope you've enjoyed this session. I look forward to seeing you again soon. Thank you.